good morning, wherever you are, and welcome to Conversations with Rudy Rivera. Today, I am thrilled to have an accomplished Mexican author, accomplished attorney, Mariana Alejandra Ávila Valladares. But how is it law? I mean, there's no statute in Mexico about collateral estoppel, is there? So how has it become law? I know it's got to be the Supreme Court that says this is the way it is, right? And then other courts have to follow. Can you explain that a little bit? Because a number of my colleagues believe that Mexico law is strictly civil law and there's no precedent, but that's changed somewhat over the years.
Yes, totally. And uh, cosa juzgada refleja or collateral estoppel precisely has its origins in Mexican precedents. In general, the Supreme Court and other federal tribunals in Mexico can create precedents. So even if it's not in a written law or a statute as such, it is also mandatory for inferior courts to apply it. So this theory has mainly developed through several federal precedents here.
It seems to me that now the issue of collateral estoppel or cosa juzgada is probably more important now, even after the judicial reform.
Yes, it certainly is.
And can you tell us why? I have my opinion why, but you're my guest and I want to know why you think it's very important.
Where for starters, I think that since we have newly appointed judges whom not necessarily have experience in the judiciary branch, I think that having previous decisions from experienced tribunals really is useful to have continuity in the dispute resolution in Mexico. So for me, that's the most important reason why cosa juzgada refleja or collateral estoppel is important today.
But there was some talk in Mexico about opening cases that have been closed, and even President Sheinbaum, to her credit, said, "Wait a minute, that's ridiculous. Those matters have already been litigated. Why are we going to open them again?" Who was it that was behind that?
Well, the problem nowadays in Mexico is that probably legal and political issues are a little bit intertwined. So I think that it has a little bit to do with that. But I have some good news on the subject because the Supreme Court on January of this year had a discussion about res judicata regarding a particular case. But in general, I was very relieved to see that, for example, the president of the Supreme Court said that res judicata is one of the fundamental pillars of the rule of law, and that that hasn't changed in Mexico, even though we have had a judicial reform. So I think those are good news because it appears to be that the Supreme Court will continue to ensure that the principle of res judicata is respected.
I think I agree that that's important, and I think that opening up all these cases would lead to just chaos in the sense that it makes an uncertain legal system in Mexico now even more uncertain. You can never know that a case is truly done. It's bad enough that some of these cases can take years. But now that you conclude, say, after 10 years, and well, can they come back? Can they argue this? That's I think, I think collateral estoppel is the safety valve.
Yes.
Once the dispute is over, the dispute is over. But in Mexico, they don't recognize the difference like we do in the States. I mean, they don't have different names for it. So in Mexico, it's cosa juzgada, but it applies to the same parties and also to an issue that was already litigated. It applies to both in one concept. Am I correct with that?
Well, they have similar names, but there is a difference.
Hmm.
Your res judicata is our cosa juzgada,
Right.
And your collateral estoppel is our cosa juzgada refleja. So they just added this adjective,
Hmm.
but there's a distinction in the names as well.
And how often do you see this in your litigation, where you've had to litigate issues of cosa juzgada?
I've seen it quite often, actually, but what I've also seen is that Mexican tribunals aren't very well informed sometimes about this new institution. So res judicata is applied um, very well because it's a known figure, but collateral estoppel not so much because I think it's too new for our tribunals and it's still a doctrine in evolution.
Well, we have a comment from Marcella says Mariana's book was extremely useful in the analysis of a complex case we are handling at our firm. Thanks, Mariana.
Thank you, Marcela.
And actually, we did. I read your book, but we did use it. I've encountered cosa juzgada in a couple cases I've handled in Mexico. One in Mazatlan, where an agrarian group sued the municipality for 100 hectares of land, but they only got 50. Then they sued our insured to get the land that they wanted, and the court said no. Your remedy was to appeal the decision of the municipality. Now that you didn't do it, you're barred from claiming the additional land. So that was in the U.S. term, a collateral estoppel.
Yes.
Hmm. And then I had another case in, I think, Guaymas, where it was the same issue. The agrarian group went to the municipality, litigated, they lost, and then the Court of Appeals said, no, no, cosa juzgada, and the case was over with. So
Yes.
I can attest as a foreign lawyer that it's a very useful tool in litigation. And to me, it's important that lawyers do their homework as to the parties. As has there been any other litigation concerning these property these people, especially in real estate transactions and um, what other situations do you find this coming up more?
I've also seen it a lot in guarantees, for example, or in subcontracts, where, for example, in a first trial, someone is found liable and then they have to sue, for example, a subcontractor. So I think that particularly in complex contractual relationships, this is going to be very interesting.
And what do you well, when you say that there's a separate proceeding for damages, is that what you're saying? That there's
Yes.
liability? See, in the US, that would be decided all in one. The only time the actions are bifurcated when it comes to the punitive damages.
Okay.
You have to show intentional harm, and then if you win and the jury rules in your favor, even with your actual damages, then you have a separate hearing on what they call the punitive damages. But that doesn't fall under collateral estoppel with us. That just falls under, it's the same case.
But if it is against a different person, for example, the first trial is between the owner and the contractor, and say the contractor is found liable, and then he wants to sue a subcontractor in another trial, would that be possible in the US?
You would have to have mandatory inclusion of anybody who's involved with that. In
Okay.
other words, it's called joinder of necessary parties. And
Okay.
so if the contractor had some liability on that, then you needed to bring him in the case.
Okay.
Because otherwise you do have then multiple litigation that's doesn't make any sense. So in
Yes.
your example, we would have to bring in the subcontractor, or we won't be able to bring him in separate proceedings.
Okay.
There's two types of joinders, mandatory and permissive. Permissive maybe you're entitled to an offset. Um, based on another contract, but mandatory means you're involved in the same issue.
Okay.
But in Mexico, you would say that that's cosa juzgada.
Yes, I think that collateral estoppel would probably apply in those cases.
And what other situations have you seen it apply?
So I was saying in guarantees, for example, there's a principal debtor in the first trial, and in the second one, you're suing the guarantor, for example. So it will be a logical first step to analyze whether the principal debtor was in breach of contract or not, to analyze if the guarantor is liable as well.
Well, you quote in your book um, Giuseppe Chiovenda, who basically says that cosa juzgada strictly refiere al bien de vida perseguida en juicio que una vez reconocida o negado llega a ser incontestable y inatacable. Basically, it makes a sentence unattackable and final.
Yes.
And who is Giuseppe?
Now, this is a very famous author, procedural law. He's Italian, and he really has written a lot on res judicata and collateral estoppel as well.
And, but in the United States, res judicata and collateral estoppel is an affirmative defense. You have to raise it as a defense when you're being sued in a separate proceeding. How does that work in Mexico?
Well, in Mexico, cosa juzgada is considered to be part of the public policy. So actually, tribunals, if they realize that they are in front of either cosa juzgada or collateral estoppel, they could also apply it, even though the parties hadn't raised it in the trial.
In the US, you have to raise it as an affirmative defense. And I guess the court could on its own say, well, wait a minute, this matter was litigated before. But generally, the judges don't really do research in state cases. I mean, they rely on the parties. Federal judges do more research, but they would have to know to look for that. And the only person who's in the best position to know, or the people in the best position to know, are the parties. But how would it work then if a court finds that the case or the issue has already been litigated? What will the judge do? Dismiss the case?
Yes, he would. Well, it depends. If we're speaking strictly about res judicata, yes, the judge would have to dismiss the case. But if he detects that there is collateral estoppel, he would have to decide on the merits of the case and decide what influence does the prior ruling have in this second trial, because the claims will be probably different. So the effect of res judicata would be to dismiss the case, and in the case of collateral estoppel, the judge would have to give a decision on the merits, but considering the previous ruling.
Well, let's assume that a party doesn't raise it and the court doesn't notice it, and then there's a judgment. Can that judgment be attacked afterwards?
If it's already just judicata,
Well, no, the first case is res judicata. Then there's the
okay.
second case. Nobody raises it. And the appeals, the revision, the amparo before the Supreme Court, that's all done. Then all of a sudden, after all the appeals have been exhausted on the second case, we find out, wait a minute, this cause was already litigated prior. What would happen there?
That's a very interesting topic. I think that what would happen is that the second ruling would have to be respected if it's already res judicata.
So you could have two inconsistent judgments.
Yes, I do think so, but I think that in this case, the second ruling would probably create new obligations or a new legal situation because if it's res judicata, I think you would have to respect the second one, but it's very debatable.
I think it's an unanswered question. Nobody knows
Yes.
what will happen because I think you can make an argument that, well, this judgment, the second judgment, is void because the court had no jurisdiction to enter this because that was already litigated. And in the United States, for example, a void judgment is a void judgment always, so there's no statute of limitations.
Okay.
I
I
had,
don't
I
think
had,
that would be the case here, to be honest. And actually, one of the partners in my firm has written on rulings who create obligations. So I think this might be that case in
well,
Mexico, at least.
yeah, there was a case in Puerto Rico where the state court declared a certain deed invalid and void, but it didn't bring in all the necessary parties. So a federal court down the road said, "Wait a minute, that judgment is null and void because you didn't bring all the necessary parties." So I would think that the more sound approach is to basically say that the second judgment is not valid because now you have two final judgments that are inconsistent.
It's a very interesting topic.
And so, my other question for that is, how do you know? Because it's difficult to find stuff in Mexico. It's difficult to look at cases that you're not a party to, let's say. And, you can go on the court's website, but, you've got a foreign lawyer being represented. Um, he wouldn't even know to ask about collateral estoppel. He wouldn't know what was pending before. How would you find out? You're my lawyer. What would you do? Would you look to see if there were other cases? Would you? You see, like in some cases, there are other parties that you don't know anything about. For example, in the case of real estate transactions, you may have some agrarian group that tried to get it 20 years ago and they didn't get it. So how do you do that investigation? You as a litigator, how would you recommend that investigation be done?
Well, I would probably recommend precisely going on the websites of the tribunals and the official gazettes of the Mexican tribunals and probably try to look for the names you know of related parties. But I agree with you, it is a very difficult task. Is it difficult in the US?
No, it's very easy because it's the federal, there's a PACER federal court system that you can look up unless it's under seal. You can
Okay.
look up a case. Even if a case is under seal, you'll have the name of the case, but then you won't be able to read the documents.
Okay.
And in state court, you can pretty much see about every case in every state, but you may not have access to certain documents. And in the case of juvenile law proceedings, those things are closed. Nobody has access to those. And in the case of dissolution of marriage, I think some states have limited access to those things because identity thieves go in and get social security numbers and credit card information and try to steal identity. So that is easily um, researchable. You can do a search on a party and see what litigation they've involved in, what state. There are services that provide that for a fee. But you don't have that in Mexico yet.
Well, we do have private corporations who can investigate. If you give them the name of a party, they can tell you in which cases he has been involved, but you wouldn't have access to any of the information, so it probably would be no use.
Well, we have another question is, can you explain if la cosa juzgada refleja applies if the parties are different? How are the courts in Mexico resolving these cases?
Okay, so this is part of the things I criticize a bit in my book because currently the collateral estoppel doctrine in Mexico is limited strictly to the parties. One of the requisites that the precedents have included for the collateral estoppel to be applied is that the parties from the second trial in which the collateral estoppel is invoked were bound by the first ruling. But I think this is a huge mistake because there might be a lot of situations in which the parties are different, and nevertheless, the first ruling is necessary or interesting to be considered to decide the second trial. So, my experience is that currently Mexican tribunals aren't allowing the collateral estoppel if the parties aren't the same. But I do expect that this will change because I don't think it's that logical.
But I've had the two cases I've discussed. That's exactly the doctrine applied by the judges in the cases, arguing that you should have appealed that decision, and now perhaps it's a little different. But so you have an agrarian group that says, I want 100 acres, and the government only gives them 50. So they sue. So basically, when the government only gives the agrarian group 50, the government's saying, well, you cannot have the other 50. The other 50 is not yours. This is all we're giving you. Okay. And we were able to use the argument of collateral estoppel, cosa juzgada, to saying, no, that's already been litigated. They have no legal right. So if they have no legal right, they cannot file a lawsuit here. How would that be different or similar?
Well, if I'm understanding correctly, in your case, what you applied was, well, what you invoked was res judicata, but not
No, it
precisely
would have been more
collateral
collateral
estoppel.
estoppel because the owner was not involved in the prior litigation with the agrarian group.
Okay.
So it
But
would
did
be,
you,
huh? Go ahead.
this is just for academic purposes, did you invoke it as res judicata or did you name it cosa juzgada refleja? Because I think that's interesting.
We named it Cosa, I believe. I have to go back and check, but we did it as Cosa Juzgada, but it couldn't be Cosa Juzgada because the parties were different.
Yes,
So it would have to have been Cosa Juzgada Refleja.
yes. Yes, I think there's still a little bit of confusion in the tribunals because I agree with you from listening about this case that it was collateral estoppel, but I probably think that tribunal didn't understand it as such. It applied it as res judicata, even though the parties were different. So I think it's a topic that causes a lot of confusion in the tribunals. But I mean, officially in the precedents, the a requisite for the collateral estoppel is the identity of parties. And
And
as you
so,
said, sorry,
go ahead, go ahead.
as you said, there are a lot of cases in which parties are different, and this has to be used.
Well, but so you're saying then Cosa Juzgada Refleja is not the law yet, because that's what I gathered from your book, that it's not really recognized.
Well, it is, but not in a statute or written law, only in precedents, with
Cosa
also
Juzgada
more
Refleja.
mandatory. Yes,
Hmm.
and res judicata is included in our civil and commercial codes. So that
Okay, okay.
is,
Okay, so that's the difference. One is the code and the other is basically precedent. Well, we
yes,
would say
exactly.
common law. And how has that developed? Is it that it developed? Who said, wait a minute, this is stupid. We have to have this doctrine of cosa juzgada refleja.
Well, it was the one of the extinct chambers of the Supreme Court who
Hmm.
started this doctrine because there was a case in which, in a first trial, it was decided that a contract was terminated. And in a second lawsuit, one of the parties asked for the specific performance of that contract.
Hmm.
So the Supreme Court said, even though the claims are different, we must not ignore that there is a previous ruling that already decided this contract is terminated. If we are studying if we should order the specific performance of the contract. So that those were basically the origins of this new theory, because they said the previous ruling must have reflective effects on our second ruling because it is a necessary logical precondition for us to rule the second case.
You have a very nice cartoon in your book about a flashlight being shined on. You have the first case, the second case, and you have a flashlight, like
Yes,
shining the light on the issues. Because of course, without with the cosa juzgada, the case will be would be decided differently, right?
exactly.
Hmm. It's like having a void. In other words, once you know what's there, you're limited as to what you can do. In other words, once you know that this issue has been litigated, then you just maybe litigate the collateral issues, which could be damages, it could be other issues between the parties, right? But the bulk of, but how often is cosa juzgada a problem? Because if it involves the same parties, then I guess the way I'm trying to phrase this question, see, like with collateral estoppel, cosa juzgada reflejada, you don't know or may not know that something's been litigated. But with cosa juzgada, res judicata, you would know because you were a party.
But since the current requisites for collateral estoppel in Mexico include the identity of parties, then you would know because we're assuming you were a party also in the other trial. So I think,
Exactly. So you would have to know that. And,
yes,
and you would have to know that there was this lawsuit before and you won, right?
yes.
Now, in that case, assuming that the lawsuit comes about, would then the plaintiff who files the second lawsuit be subject to a frivolous lawsuit, damages for a frivolous lawsuit, or even under criminal proceedings for abuso del proceso, abuse of the process?
Well, I think it depends a lot on the circumstances, but in the case of collateral estoppel, I don't think so because probably the second claim isn't the same as the first one. So he is in his full right to file the second lawsuit, I think, because the claims are different.
Well, I mean, not, but then it wouldn't be res judicata if the claims are different, right?
I meant in collateral estoppel, but in res judicata, I do think that the plaintiff would have at least to cover the expenses of the other party
Yeah,
to,
that's what my question was geared for, the res judicata, because
yes,
you lose it in case number one and you go to case number two and you're subject to damages, but I think you would also be subject to criminal liability too.
yes, I do think so.
And but with collateral estoppel, yeah, that's it's a little different story, right?
Yes,
Because I can see where people would forget, you've got an organization that the president at one time filed this lawsuit, nobody knows about it, and then somebody comes up and says, "Hey, this land is ours, or this thing is ours. We're going to file again." And even the people filing the lawsuit may not know that it was something that was litigated before.
yes.
Now, how do you think this will, you know, if they follow this doctrine, how do you think it will help in all the chaos?
Well, I think that it is very useful, particularly with newly appointed judges, because I think they can base their decisions on previous rulings that are related. And I think it's also, um, well, it's homework for advisors for litigators and for parties to present these newly appointed judges with the information in a way that they can resolve in a coherent manner. So I think it's just a tool to ensure that in parallel proceedings, coherence is respected.
We have another question. It says, un causaviente de una de las partes puede invocar la cosa juzgada refleja.
Okay, so I think uh, causa viente, is that a privy? Privy in English? I'm not sure.
Privity, yeah. Well, we'll
Privity,
have privity,
okay.
yeah.
I think he could do it because, for example, regarding res judicata in the civil code, sorry, civil procedural code, causa viente is considered a party as well. The effects of the res judicata can be extended as well to the causa viente. So I think I've never seen it in practice, but I think that it would be possible to be considered as a party as well.
Well, the whole question is, un causaviente de una de las partes puede invocar la cosa juzgada refleja. Entiendo que en este caso se considera que el causaviente queda sujeto a la sentencia ejecutatoria del juicio previo, asumiendo que se trata de la misma causa y el mismo objeto.
And yes, Marcela, I think you're absolutely right. I think that since the effects of the first ruling are extended to the causa viente, I think that he would validly be able to invoke collateral estoppel.
So he would sit in the shoes of the person. The causaviente basically is a person with privity or a third party. I've seen it a lot in Mexico, tercero causaviente.
Yes, I think that causa vientes are included in the current hypothesis of the collateral estoppel in Mexico.
And do you think that, well, you say it's a safety valve because then it'll allow judges to go back and look and see if the matter's already been litigated, that just say, why do I need to litigate this case?
And also, what's very interesting about collateral estoppel is that it sort of is a bridge between the different types of law. For example, if there is a ruling in a commercial dispute, this might be used also before, say, an administrative tribunal. So I think that's also very useful because in the complex disputes we have nowadays, I think that sometimes investors might have several proceedings in parallel, whether administrative, amparos, or commercial disputes, and collateral estoppel also can help us to coordinate all these parallel proceedings.
You say in your book in chapter 2, the regulation, la regulación, it says a propósito de de los efectos reflejos que puede tener una sentencia en procesos diversos, aquel lo cual fue dictada ha sido introducida en nuestro derecho de figura de la cosa juzgada refleja. Su regulación positiva es mínima, dado que la mayoría de las legislaciones objetivas no contemplan. So what you're saying is that this is not thought of in the civil code, but there are some states like la Ciudad de México, Código Federal, Procedimientos Civiles, cosa juzgada refleja is there.
I think that the only states that have a regulation in their procedural codes are Michoacán, I think,
And Jalisco.
and yes, and Jalisco.
Mhm.
But the in Mexico City and in the federal procedural code, we don't have a regulation. Those are the only two states that had included this collateral estoppel institution in their codes.
Well, and chapter, you talk about the definitions, cosa juzgada refleja and cosa juzgado, just cosa juzgada. And can you tell us what the elements are? Just break it down briefly, what the elements are for cosa juzgada refleja?
Okay, yes. So the basic elements are that first, that there is a previous ruling that is res judicata. Second, according to the current precedents, that there must be an identity of the parties. And third, that the subject matter decided in the first ruling is important or a necessary logical precondition to rule the second trial. I think
Okay.
those would be the basic ingredients.
And cosa juzgada means between the same parties.
Yes,
Now, do you have to include every legal issue between the parties? And when it's cosa juzgada,
yes, yes, you have.
whatever cause of action you have between the two people concerning a subject matter or a set of facts, you have to bring it all in the same proceeding.
Yes, according to the procedural civil codes, you have, but in court, you normally see people handling cases in a way that this rule is not applied strictly.
Yeah, well, Marcella and I read your book, okay? So, which is why you're getting these questions. In Mexico, all lawyers will tell you that they know exactly what cosa juzgada is, but sadly, few actually do. What's your thought on that?
Uh, Probably I agree.
You can say you
Love
agree.
that.
You can say you agree.
Well, cosa juzgada, I think that is a general, uh, it's of general knowledge to Mexican lawyers. But regarding collateral estoppel, I probably don't think that's the case. I think it's a hidden institution that few truly understand. So, res judicata, I think most lawyers have a good understanding on res judicata, but on collateral estoppel, I don't think so.
But for me as a litigator, as a former litigator, I was a litigator in a prior life. Now I just manage litigation. Um, Cosa juzgada refleja would be a very powerful tool because these cases I've been involved in are 7 volumes of information. If you can get rid of a case that way, I think you give the judge a way out. And in light of the judicial reform, in light of the fact that a lot of the judges are not educated, not I won't say not educated, but not trained, not career judges or elected officials, to me it seems like it would be a way out for them to get out of a case. Especially if the cosa juzgada refleja is in your favor.
Yes.
Yeah, what I find is that much of the litigation in Mexico that my colleagues have been involved in have been, frivolous lawsuits, especially in the area of real estate. You've got somebody coming in to see a developer's coming in to build something, and some people say, let's file a lawsuit. Maybe they'll just pay us to go away. And they try to get an injunction or put a lien on the property. Um, in breach of contracts, it's the same thing, right? Well, we know whether they're not in breach, but let's just file it anyway, right?
Yes.
And so, talking a little bit, we got about 15 minutes left. If anyone else has any questions, feel free to just, you know, text away. Um, with this instability in the Mexico system, and trust me, I've been involved in Mexico for 15 years, okay? To me, it's always been somewhat unstable in a sense, depending on where you are. I've always thought that if I lost a case in the first instance, la primera instancia, I wouldn't be surprised. but I hope that I'd win in the revision and in the Corte Suprema. Okay, and that's exactly what's happened to me on pretty much almost all my cases. But what advice would you give to somebody coming into Mexico and they talk to you and say, Mariana, we want to come in, but we're scared. I mean, how can you protect us, or what would you advise as to how we can be as best shielded as possible? That may be too broad of a question, but I think you know what I'm getting at with it, right?
Yes. Well, I think that first you should take preventive measures. And by this, I mean that you should draft properly your contracts. For example, in my law firm, we have like this dual system for contracts. The corporate team drafts the contract, and then the litigation and arbitration team sees it with these lenses as a litigator to see which aspects can be improved. Because if the contract eventually ends in a dispute, you must want to have a solid basis to litigate. So that is like the preventive measure. And also, what has been developed a lot is to do more elaborate dispute resolution clauses as well, either multi-tiered clauses or arbitration clauses. I think that arbitration is going to be a very useful mechanism in our current context in Mexico.
Well, you're preaching to the choir. That's an American expression. You're preaching to the choir, okay? It means that I couldn't agree with you more. Um, and I've seen mm, with my colleagues, I'm very active with the Association of Corporate Counsel. So colleagues ask me, who would I recommend in Mexico or anywhere in Latin America and even other parts of the world? And they don't take the litigation aspect of the contract into consideration. You know, they just say they just write in a boilerplate clause without thinking about it. So, for example, if you're going to go into Mexico, I would agree that you'd want to put in an arbitration clause and possibly a pre-mediation litigation clause. That's very common in the United States, especially under mega contracts. You agreed to mediation between the businesses before anybody can file a lawsuit or an arbitration. Um, However, even just saying we're going to arbitrate requires much more thought because who do you arbitrate with? There's CAM, there's AAA, there's the Chamber of Commerce, or Singapore is coming in now. Singapore arbitration centers coming in. European lawyers are trying to bring in, you know, their arbitrators because they feel that in Mexico it's a very small club and they all kind of know each other and you may be an arbitrator in one case but a party on the other case. So I think even that needs deep analysis, right?
Yes. And also, I think that parties should also consider mediation and negotiation more. Because I think that settling a dispute before it explodes, it really is beneficial for the parties. For example, in my law firm recently, I think we might have terminated more disputes through settlement agreements than we have by final rulings. And I think that clients have been very happy that this happened because they saved years and years of litigation and probably a lot of money. So I think that we should change a little bit the perspective towards ADRs and use them more because they really will be a necessary tool in Mexico.
Well, I got to ask you something about that because every effort I have ever made to mediate in Mexico, and not just Mexico, in Costa Rica, in Ecuador, has been the other side trying to convince me that they're right. And nobody wants to throw a number out. They don't want to say this is the first number. They want you to give the number. Or if you say to them, well, you're I think you're wrong, but let's look for a business solution. you know, or because then the lawyer tells the client, we're going to win. Well, if we're going to win, why do I need to compromise? I want the whole thing. So I have found it personally, and I'd be interested in anybody else who's on the panel. I see there's some Mexican lawyers there. What success they've had mediating. I know there's some legislation on mediation in Mexico, but honestly, well, I had one mediation where the plaintiff's lawyer went out screaming because he said the other lawyer was impugning his integrity. He screamed and walked out, you know. Um, but and the other reason I asked this question, I know it's kind of being a little wordy, but also they look at mediation as a sign of weakness. If you want to mediate, then there must be you don't think you have a good case. So let's take advantage of them. So could you comment on what I just said?
Yes, of course, I do think that we have to change the mindset a little because in our culture, normally parties do not they don't feel comfortable with negotiation or mediation, but I think it's a problem of mindset. And another thing that I think is important is that you as a party have an objective diagnosis before you consider mediating or negotiating, because I think that sometimes many attorneys just tell their clients that their case will be an easy win, and thus parties think that they are right. And
Mhm.
probably that is not the case. So I think it's very important that us as attorneys and as advisors give our clients a real and objective analysis of their situation and to really explain them where they are standing, because this many times is makes possible for the parties to want to negotiate when they know that they don't have, they are not right in everything and that they can lose before a court. So I think an objective diagnosis from the advisors is fundamental.
But that's the problem. They don't get that objective diagnosis because I've been involved in mediations where I say, how much do you want? And they won't give you a number, and then they want you to keep coming up with a number. I've been in Costa Rica in a mediation where the guy spent a half hour telling me that he's not wrong. Well, if he's not wrong, why are we here to talk about it? There's a comment which is really good. The alternative is to spend years in court. And I agree with you. That's the alternative. What often happens is some lawyers will just keep collecting money every month or keep billing. So they have an incentive to do that. So I think the moral of the story here is be very selective about who you retain in Mexico, because one of the downsides to Mexico is there is no bar that sanctions lawyers. And so lawyers can do what they want. I've been a lawyer for since 1980, and I've won cases I should have lost and lost cases I should have won. I mean, that's just the way it goes. But I think in when you have, and I know if I'm going to win a case, I know why. And I know if I'm going to lose a case, why. So if I, for example, I lose an arbitration where there's been disclosure, yeah, I know why I lost, okay? But in civil cases where there's no discovery, it makes it a little bit more difficult because you don't necessarily know what they have that's weak. Somebody says we have Emilio says the clients are aware of such issue, they prefer fast settlement. Well, Emilio, that's probably your clients because you're giving them good advice. But trust me, I've been in almost every state in Mexico and I've not seen that advice given. But I agree with you, Emilio. I mean, that's what should happen. Any lawyer should say it's to your benefit to let's try to resolve this thing if we can. And 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 a good compromise, you know what a good settlement is? When both parties are a little happy and both parties are a little glad. Because you don't get everything you want, but you're
No,
not going to lose everything, right? So you
but
got
you
to
get
have
it
something,
fast.
huh? Yeah, exactly. And I find that it's important to prepare for the negotiation. And
Yes,
some of the negotiations I've been involved in, the other side is not prepared. They
yes,
just say,
that
no, this
also
is what I
happens.
want. Explain it to me why, Well, we were going to talk a lot about I think we've covered it enough, the new reform, and I think everybody's covering it too. But I just really thought because of some cases I've got, your book on collateral estoppel was fascinating. And we're actually, using it, uh, the context. So it's been super helpful. For those of you who don't know, if you came in later, um, Mariana wrote a book, La cosa juzgada, refleja en México, Mariana Alejandra Ávila Valladares. She is a partner in a boutique law firm. Her book is available on Kindle. And let me just, where is the share screen? We'll share the screen with you. Right there's her book. You can get it on Kindle. It's a good read. It's not. I don't find that it's written in plain English. I find, Marianne, it's very straightforward and understandable. So somebody who doesn't know the Mexican legal system um, could really read it and get a lot out of it. So that's La cosa juzgada refleja en México. We'll stop sharing now. And if anyone wants to reach you, can you send a text to our audience on how they can reach you if they have any questions or if they need a lawyer?
Yes, of course. Should I put the information in the
Yeah,
chat?
put in the information in the chat. Yes. Okay.
Okay, I will.
So,
And thank you very much, Rudy. It was very interesting for me to listen to your perspective since you have been in so many jurisdictions. So it was really very interesting for me.
well, when you're old like I am, you do a lot of stuff, okay? When you've lived as long as I have. So I want to thank our Zoom audience. I want to thank our LinkedIn audience for showing up and listening. I think for a very technical subject, we had some really pretty good attendance for this thing. And so I'm really happy. I wish you the best of luck in your career. I just think you're going to be one of the rock stars in Mexico. Just
Thank
keep
you,
keep
Rudy.
keep up what you're doing, and I look forward to meeting you in person when I'm in Mexico.
Likewise, Rudy. Thank you very much.
Thank you, and goodbye, everybody. Have a good night.
Bye bye. Thank you.